record this meeting. Okay. We now have a quorum and we'll begin the meeting. This meeting is being recorded with the permission of the chair, co-chairs. I will start with roll call. Tom Green, Rebecca Sandifer.
Present.
Marta Alkenbrock.
Present.
David Engstrom.
Present.
Kevin Moore.
Here.
Toby Rothschild. I think Toby's here.
Oh, he's
Oh, he's on
muted.
mute.
I'm here. Sorry.
Okay, double checking. Patricia Spitiero.
Here.
Thank you. And next, hold on. Angela just sent me a message. Tom needs the link. Hold on, let me resend his invite again. But you can go ahead with announcements in the staff report.
As co-chair, I have no announcements.
Okay. Then I guess we can move on to the action summary, approval of the action summary. If I can get a motion to approve the February 10th meeting action summary.
So moved.
Just to,
Yes, Rebecca?
it's fine if we're going out of order. We just didn't ask for public comment yet.
Oh, sorry, I totally forgot about public comment. Sorry. Are there any members of the public that would like to give public comment testimony? If you could please use the raise hand function to indicate that you'd like to speak. You'll be given 2 minutes. Doesn't look like we have anybody from the public that'd like to speak.
Great.
Okay, should we move on to the action summary now?
Yeah, so we had a motion to approve the action summary.
Yes.
Do we have a second?
Do we have a second?
I second.
Okay, thank you, Patricia.
Yeah.
All right,
All right.
we'll take the vote. Tom Green, Rebecca Sandifer,
I'm all in.
Marta
Tom's ready.
Alkenbrock,
Yes.
David Engstrom,
Yes.
Tom Green, Kevin Moore,
Yes.
Toby Rothschild,
Yes.
Patricia Scutiero.
Yes.
Okay, thank you.
So I think that concludes the preliminary part of the meeting, and we can leap directly into the meat. I want to thank the folks who took the time to not just think about some of the key issues that we're going to be working through today, but also to write about them so that we could all see them in advance and think them through a little bit more. Those were great comments. I learned a lot from reading them. So Tom and I, and Tom's going to be here soon, I promise. Tom and I were hoping that today we could, so this is our aspiration, that out of this meeting comes some principles around the purpose of the sandbox and the sort of its limits, where the walls are and what the walls are made of, that we can pass along to the larger group for discussion at the next full task force meeting. Because we're trying to be efficient, our thinking is we would spend about 45 minutes on the purpose question. So to try to get this group to a point of agreement about what we want to send forward in terms of principles. And then about 45 minutes on the sort of what are the walls made of and how high are they question. And that would leave us, if we can get through all that in 90 minutes, that would be really cool. And then we'd have 30 minutes left to talk about, I mean, once those principles are decided by this group, what the application looks like is dictated to some extent, right? So what it needs to know and so on. So hopefully we would have a little bit of time to think about how to translate those first two establishments into what the application would look like. Does that make sense and seem like an okay plan? So just as a way of getting us something to work with, Tom and I, in the first memo that we sent, put together different summaries that just reflect what we heard, right? Of the conversation at the last big group meeting about what the purpose of the sandbox is, how to think about the public protection objectives and so on. And we offered summaries of of what we understood to be positions that came out of those conversations. So one way we might do this is start with that as a kind of raw material, or at least a straw creature to beat up on. And so if that works okay with folks, then we have the first question which is what is the purpose of the sandbox? I'm going to open this up for discussion, but I'm going to say that we don't have to focus our discussion around. What we're after here is what substantive bullet points do we want to send to the group about the purpose of this activity? And if you look at the two approaches that came out of the conversation as we summarize them, one of them says it's about testing whether changing the rules is good, right? Is it good for consumer protection? Is it good for the expansion of access to justice? And the other says it's about collecting information that lets deciders make decisions. Those are totally compatible approaches. But sort of does this group have thoughts about that part of it? Like, what is the ultimate reason that we're doing this?
I'd just like to point out that Neil has his hand raised. I don't know if it's to give comments or if it was on accident.
Yeah, it was to give comments. So, so I apologize, folks. I wasn't able to really look at the document carefully until yesterday. And so I did make some suggested edits to the purpose statement. And so I'll try to make that visible to you folks via my screen. Okay. Can you folks see that? Can you see it? Okay, great. So,
Yes, we can see it.
yeah, and again, I'm sorry for not being able to look at this sooner. But of course, these are just suggestions. So I kind of, I liked both approaches, but I just wound up taking approach number 2 and editing that. So one of the things I did is I changed the word test to monitor and assess, just to be a little bit more precise. And then added the word prohibiting non-lawyer participation in the practice of law. And then instead of listing out the possibilities, I sort of related to David's comment about, well, what about matchmaking type models and things like that? So I thought maybe just leaving that out would be more open. And then I thought it was important to hit the word innovation, generates innovation. And then I tried to sort of follow up on what innovation meant and that it should be objectively measured as being in the public interest. And then I tried to add, in terms of what are the objective aspects, sort of those 3 bullet points: the expansion of access to justice by providing competent legal services. Toby and Patricia, you were really emphasizing that point about, the services have to be good. And then also, part of what we're doing, I think, with the sandbox is trying to identify the regulatory barriers, right, that would maybe prevent expansion in terms of access to justice issues. And then the last thing was something that came out of the last report out of ADLS about a balancing test, whether the potential benefits of any increased access to legal services afforded by the innovation substantially outweigh any identifiable harm to consumers. So I'm sorry that's a lot of stuff to look at, but again, these are just suggestions.
So thank you for compiling this. I would love to open this up to the group for thoughts. I just want to put one kind of activity bound on us. So the temptation will be to be incredibly wordsmithy. And our goal today is really just to sort of lay out the substance, and then we can worry about the language later. So, but do folks have comments on the substance of what Neil has put together?
So Becky, I had a little technology problem here. Did you mention the time limits that we discussed?
I did.
Good, thanks.
So you have 36 minutes. We have 36 minutes to figure this all out.
And if it would help, I could put up a clean version.
Neil, so you took the second proposal, is that what this is?
That's correct, yeah. Again, I can put up a clean version if that would be easier to read.
I have sort of an
Neil,
initial,
could you enlarge it on your screen a bit, please?
Yes, I should be able to. How's that?
That's much better.
much
Thank you.
That's better.
I can't make it 3D though.
Oh, bummer, okay.
We'd have to have the glasses.
Exactly.
I have an initial thought, and that is that I kind of liked the language in approach one in the parenthetical that is left out of this, and that is when it in this version, when it talks about expanding access to justice, how are we defining that? And I personally, at least, would like to see the focus of that expansion being on unserved and underserved residents and small businesses, and not the universe of potential access.
Well, that is in the first bullet point.
Oh, you're right. It is there. I didn't notice it. Yeah. Okay. Sorry.
And actually, I was trying to do the same thing, Toby. I was trying to sort of mesh both of them together.
Yeah. Good. Yeah. No, that's good.
But like Becky said, this is more about concepts. The wordsmithing, right, can happen later.
Yeah.
Yeah, this is, I do think, I like a lot of this, but I do think an important aspect of this, which was in approach one in the draft that we sent out earlier, is the idea of information gathering being part of this. I think, Neil, in part you've got that idea, but partly we are kind of the midwives for other regulators and legislators. So I think part of this needs to be not just we're going to open up the market, but we're going to help others understand how to do it, assuming they want to do it. So I think that is a concept that I like quite a lot, and I think that's very consistent with what our ultimate charge is from the bar. But I do see some elements of that, but I think it would be better if it was clearer. Frankly.
One of my comments, just again, reading this for the first time, which I appreciate, Neil. I mean, I appreciate the work you put into this, but the thing that has me paused about this process is the relaxation of rules prohibiting non-lawyer participation. That's my concern about this process is relaxing the rules, maybe it maybe modifying the rules. I know we're not supposed to wordsmith, but
Changing?
what?
Changing. Whether changing the rules about non-lawyer participation.
Or modifying, or
Sure.
Yeah, modifying is a lot easier to accept, I think.
Yeah.
And prohibiting is a tad strong too, because we may want to have some flexibility in terms of adjusting, expanding something that's partly expanded now or some such.
What about modifying the rules against?
Yeah, or concerning non-lawyer participation. Yeah.
concerning.
Sure.
We're doing exactly what Rebecca said we should.
I know.
Anyway.
Oh, a bunch of lawyers.
But if you're talking about this on a conceptual level, I just thought it was important to hit on the word innovation, right?
Yeah.
This is what ultimately is what we're trying to do here, and also just to put things that are objectively measurable in terms of the purpose of the sandbox. And what are we looking for? We're looking for expansion of access to justice, of competent legal services, and we're also trying to objectively identify what are the regulatory barriers to expanding that access.
So Neil, what is the metric you would use to objectively measure? What is that metric?
Well, I think it would be dependent on whatever individual applications is in front of the sandbox, but I would suppose it'd be some sort of measurement for showing, okay, you provided legal services to a group that normally doesn't, hasn't been able to afford such services.
Got it. Okay. All right. Generates innovation. But how do you measure the innovation? Is there some sort of innovation metric? I think that was where I got a little hung up, and I apologize for smithing here or something.
Yeah, no. Well, I mean, innovation, I'm trying to sort of define as being objectively increasing access to justice, and that's part of the public interest here, right?
Well, it looks to me like you're looking at innovation through its effects, right? So
And Neil, when you're talking about your second bullet point of identification of regulatory barriers, is that, are you looking at statutory? Is that what your statutory barriers?
Or the rules of professional conduct, all of those things.
Okay.
I think David's got his hand up.
oh, I can't see everybody. Please, David, speak.
So I think some of our conversation at this point has been how we define access to justice. And I thought that was something we were going to take up in, part B of the outline. And so, we can, I guess I have some thoughts about that, but that they might be best reserved for when we focus on the language there. I'm having a little trouble understanding the difference between approach 1 and 2, because I guess I wonder what the difference is between generating information and testing. Like, the purpose of testing something is to generate information. And so, Becky is, I think, exactly 20 times the social scientist I am, but maybe she has thoughts on what that difference is and why we chose that language. And again, if we're kicking the access to justice question, how we define that to something other than purpose and are rather going to hit that when thinking about intended access benefits, then it seems like the principal difference between approach 1 and approach 2 under purpose of the sandbox is that generate information test distinction. So I guess I'd love to try to get a better sense of what we're getting at there.
Yeah, actually, I can go because I think I'm the generate information guy. Becky and I were chatting earlier today, and my sense as I looked at them again is that they're very close. I think you could probably choose one or the other. I think the nuance in the first one is more the recognition that we're kind of an intermediate stop in the process, and that we have a constituency we need to provide information to. So that was really more than anything else, because I think in terms of the actual language of it, we're going to run an experiment, which hopefully will be safe and all that kind of stuff, which we'll talk about later. But it is an experiment, and there will be information generated from the experiment. Becky, did you have further thoughts on that?
Sure. I would say the information is the mechanism to achieving the substantive goal, which is finding out whether this was a good idea. And the bar is an important decision maker in that, but you can imagine other stakeholders that might also have a role to play in the decision about whether we continue to do things the way we have or whether we would do them in a different way. So it's, for me, it's less about giving a report to a decision-making body than it is running an experiment, to use Tom's words, and deciding whether that experiment achieves the goals of the rules changes.
And the idea of running an experiment is more consistent than with approach 2 or approach 1?
So David, could you say a little bit about sort of what's at the core of your question here?
I guess I'm just trying to understand conceptually what the difference is between 1 and 2, and I'm having trouble grasping it. I guess the way I thought about it the first time I read this was that like the purpose is neither to generate information nor to test anything. It's to spur innovation. I mean, that's taking the purpose up to a higher level of abstraction, and there might be some value in that ambiguity. Like our goal is to spur innovation. Why? Because it's going to generate information. It might even generate a test. In the sense that once you have a basket of examples and once you have spreadsheets with actual representations that alternative legal service providers of various sorts have performed, you can potentially run a test. Now, it may be that just eyeballing that spreadsheet is enough to perform the test, to know that there isn't consumer harm. On the other hand, maybe it's more complicated than that. And maybe it's not within the brief or the bailiwick of this experiment to actually do some kind of, I don't know, fine-grained, sophisticated test. And maybe then we really are just generating examples and information that gets handed off to policymakers who have all the apparatus that they need to do that more sophisticated test. But I guess just to circle back, I think there might be an advantage to trying to frame the purpose of the sandbox at that higher level and more ambiguous level of abstraction, because otherwise, as I read it, like generate information versus test it, those seem to be signaling something specific that I couldn't really understand.
I have the same issue.
Yeah, and I think, David, that's part of the reason why I did that edit and changed the word away from test.
But I think David's comment raises an issue that this group, I think, should grapple with, which is innovation a means to an end, or is it the end? So the way the text that Neil has given us is we're going to generate innovation because we believe or hope that it's going to lead to certain concrete outcomes that are measurable, that are not per se innovation. Or is innovation, do we want that to be more prominent in the description of the purpose, that innovation is an output of the activity, which is what I hear David to be saying.
So another way of thinking about the value of ambiguity here would be to say that if our purpose is spurring innovation, that can mean a couple of different things. It could mean, as I noted a minute ago, a basket of examples from which we could draw inferences about whether this is a good thing or a bad thing. Now, once again, it may not be that the sandbox is in a position to draw those inferences. It could be that it takes more than just eyeballing to figure that out. But that's one possible purpose to which spurring innovation could be put. At the same time, spurring innovation, there's like the logically prior question as to whether this spurs any innovation at all. So, you can set up a regulatory sandbox and no one wants to enter for a variety of reasons. Now that goes a little bit to the sage question, maybe. If you overregulate this thing, this is what Crispin has been saying from the start. If you overregulate this thing, maybe no one comes in. Yeah. But then spurring innovation that produces information and inferences not towards any particular purpose. It doesn't let us gauge whether this is a good thing or a bad thing. It gauges whether a regulatory sandbox works at all, whether it actually spurs entities and organizations who otherwise wouldn't enter the marketplace for the provision of legal services to do so.
Yeah, I don't know. I'm not being cranky here, but innovation is really a buzzword. I think what we're trying to do here is increase supply of services to a group we actually understand fairly well. If people do it with rocks and fountain pens, I'm kind of like okay with that. It need not be a high-tech solution. So I think we want to open things up so that we improve services in a specific place in the marketplace. I mean, at least primarily from my perspective. So I'm not sure what innovation adds to this. I mean, it's can we get services to folks that don't have it now or have it in a less than optimum way is kind of my sense of it. But
yeah, I think I agree. I agree with Tom, and
in some ways about that, not the rocks, but I think that the end isn't innovation. I think the end is increased access to legal services. And the way to achieve, and what we're saying is, do the current rules that we have tie our hands such that we can't get those increased access to legal services out the door? And if those current rules didn't exist, tell me your innovative idea, right? Tell me your idea of how you'd you would expand access to legal services. Because I don't think at the end of the day, what we want to report on, at the end of the sandbox is how innovative people are, but rather the result being we've expanded access to legal services. So I think I look at it more that creating innovative programs is the means to the end of increased access.
Right, and that's sort of the definition I was trying to lay out in that edit, was to say that the innovation is objectively is in the public interest, right? But I think when we're talking about business models, innovation just basically means better product, more consumers can afford it, right? I think that's just the basic idea. But totally agree with you, Donna.
I would add to that, can find it and afford it.
Right, yeah.
Could I speak to this? Because I'm not sure that we're going to spur innovation. I think the innovation's already out there from everything I heard from the people who presented to us on the ADLS task force. They just want some way to enter the legal market. And the Sandbox provides that ability of them to come in, which they otherwise can't do under the current regulatory structure. Aren't we really just trying to bring in folks? Wasn't it Rocket Lawyer was the first entity that went into Utah? I mean, they've been around, they've been doing their stuff all over the world. And then they went into Utah and they're able to do it in the Sandbox, what they have been doing elsewhere. I won't use the word with relaxed rules or anything like that. I don't know whether it's the focus is on the rules. One thing I was asked for this meeting, and I almost caused me to pull my hair out, is how can we relax the rules for the Sandbox? And I can't answer that question until I know what it is you want to do. And then I can start make suggestions as to what modifications to the rules we might be able to accomplish. First we have to ask, what do you want to do? Why can't you already do it? And if you can't already do it, how can we facilitate your ability to do it if we think you're actually going to increase access to justice to the unserved or underserved groups that we've identified?
While still maintaining public integrity and giving quality services.
Right. You bet.
And integrity to the profession of the practice of law too.
So I'm mindful of the time. So we're going to have a purpose in 11 minutes, y'all. So would it be helpful if Neil put just the unredlined text back up, and we could see if we could come up with something to send forward?
Neil, if you don't want to be the one to type as we go, I can do it as well, because I did all your changes and put it into my own document.
Oh, Neil, you're muted.
We can't hear you. Yeah.
Gotcha. No, I was in the middle of trying to accept all changes, so I'm going to reshare it.
No, here, I can just put up my version because I have a clean version of it. I can switch toggle between each, and then you don't have to be responsible for typing.
Okay.
Hold on. Hold on. Let me
We
make sure.
can criticize Mimi's typing.
All right. Can you guys see my screen?
Yeah, can you make it
Yes.
larger, the text?
So let me just put this all on one page too for now, so you guys could see all of it. Is this the text that you want to be at? You want to edit right now?
Rules.
Non-lawyer participation in the practice. Hmm. Do we, I'm sorry to be, so non-lawyer participation, I mean, if we had a group of lawyers that oversaw technology, that's non-lawyer, that's not non-lawyer participation. I mean, they're like this characterization of non-lawyer participation as being the only thing that drives this strikes me as a limitation on what we want to think about doing here. But
I would think that someone in the tech field would not be a lawyer, right? So this is really mostly about Rule 5.4, right, of the professional rules, which says,
well, several rules potentially, but yeah.
right, yeah. And those rules basically say that non-lawyers can't engage in the practice of law, right, and that lawyers can't share fees with non-lawyers. So I think, and I could be wrong, I think non-lawyer participation does sort of capture what the idea of the sandbox is, I think.
I think that's right. And I think
that's true.
I think that's right. And I think if the lawyer is operating the technology and overseeing it, to the question is that a problem today? Would they
Good
need a
point.
sandbox?
Good point.
Mm-hmm.
But I think we could, the way to potentially solve this is to go up to make it just slightly more abstract. Maybe say something like whether modifying the rules concerning the practice of law generates increased services to unserved or underserved groups in California, some version of that.
But then we would lose, well, I think as chair of this particular conversation, I think keeping innovation in there is key. At least that's what I'm hearing in the conversation. I think a question is it adequate to have the public interest defined as being these three things? Are we okay with this as the aim of the activity?
Or even more than three, right?
Well, the three bullets.
So serving people who are currently underserved, understanding what about the current state of affairs is making them underserved, and then some kind of balanced scorecard about whether new harms are outweighed by new benefits.
In a way, the bullet points are doing different things, I think. The first bullet point identifies the public interest that we hope to meet with the innovation we hope to spur or to unleash, to take Kevin's point that we're not actually spurring innovation, it's out there. Whereas the second and third bullet points are more about the information we aim to gather. So I wonder whether we could make some changes that would break the three bullets up that way. For example, I would like to make the first sentence a little bit shorter. This is strictly a stylistic thing, but if we were to go from the practice of law generates innovation in the public interest, in other words, take out that can be objectively measured.
Yeah.
Sure.
And then have the second sentence say something about how the public interest that we're seeking to advance is the expansion of access to justice. And then have a third sentence say that we aim to gather objective information about, and then those 2 bullet points that are currently numbered 2.
Okay.
I think that pencils out. Yeah.
That could work.
Mhm.
What would you like me to do before? I was just listening before doing anything. See if you guys agreed.
Well, I didn't exactly draft the second sentence, but if you put that first bullet into the sentence
Right.
for it, and then someone makes that into a pretty sentence.
Well, you could say something like the public interest to be served is increased access, da, 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 da.
Like the public interest to be served is increasing access to justice by.
Yes.
Combat legal services to unserved and underserved. Okay, that works. And then
Take out the next sentence.
And then the next sentence
right.
is about objectively measuring or objectively assessing or something with these 2 bullet points, capturing the language that I axed from the first sentence.
Or objectively identifying regulatory barriers. You can get rid of the identification in the first bullet point.
Identifying
Yep.
regulatory barriers.
yeah, I mean, you might want to make that like after California, put a comma and then and to objectively identify regulatory barriers, yada, yada, yada.
Well, what
And the
about
extent to which they balance out. Yeah.
what about leaving it a period, but just starting a new sentence? The task force, excuse me, the sandbox will, or the sandbox seeks to.
Yeah.
Oh, yeah, that works. That works. Yeah.
Yeah, I'd like it better as 2 sentences.
And I'm fine with the split infinitive.
I'm not. Let's correct it.
And then are we moving up this idea about the balance of new harms and new benefits?
Yes.
Yeah. And whether, how about and whether the potential?
Yeah.
Look at that.
Becky will never underestimate this group again.
Wait, we need to check our time.
So it seems
Did we,
like we
yeah,
have
did
a
we come in under the wire
purpose.
or did we go over?
I think we've got
Wow.
You got it with 1 minute left.
So in terms of process, I would like some kind of sense from the group that they're okay sending this forward to the larger group as a substantive statement of what we see as the purpose of the sandbox. I don't know if you want to do that as a vote, if you want to do it by waiving, I don't know. Do we have rules about this? We have a lot of lawyers. We must have rules.
You could do like a roll call vote, or you could just have people raise their hands if there are, I mean, this is a straw poll, I think, guys. I mean, we don't have to absolutely lock in here because there's going to be more conversation about this. So maybe a straw poll.
So this is Randy. Let me just mention, if you would like the full working group in April to take action, because you are formed as a committee of the working group, if there is a recommendation that comes to CTJG from one of its committees, then you wouldn't need a motion made and seconded. It would come to the committee as a recommendation of a subcommittee. That's how our board operates. And so we would do likewise, but in order to do that, because we're meeting essentially by conference call, we would have to take a roll call vote to make this language become the official recommendation of the committee, which then could be put before the full working group as a recommendation that could be voted on if the working group wanted to, without even having to make a motion or second, because it would be coming as a recommendation of this committee.
Okay, so to play that back, we need a roll call.
We need a roll call. If you want it to be that formal and to give it the imprimatur so that it's up for action at the April meeting, then that's the way to go. If you wanted not to be so pushy, so to speak, then you can present it softer. You could say this was a consensus discussion draft developed. We're going to explain to you, the full working group, why we think this works. And then maybe someone from this committee would make the motion that it be adopted by the working group, and then there would be a vote. But there are two ways you can go, basically.
Yeah.
I have
Becky, what do you think? I'm thinking soft, but I think we've probably got the votes to pass this too. But
yeah. Could I make just one request for a friendly amendment? And you might disagree, but in the second line, could you change generates to facilitates?
Oh. Yeah, that works for me.
Sounds good.
And what about adding currently before unserved and underserved in the second sentence?
Yep. That's an improvement.
As long as we're going back to the wordsmithing game here, what do we get out of to monitor in the first line?
Sorry?
Right?
What do we get out of to monitor in the first line?
The reason why I use the word monitor is to make clear that there will be a regulator that is looking over whatever applicant is entering the sandbox and watching over it.
Isn't that implicit in the idea of assess? But what do you think?
I think from a consumer protection point of view, it's better to include the word monitor. But that's just me.
Meaning they're being regulated in a sense.
Mm-hmm.
I'm good with monitor.
Okay.
Okay, folks, so.
On the third sentence, I'm sorry, if we still have time to wordsmith, I have suggestions, but if we don't, we can move on. On the third sentence, I would like to move to, let's see, objectively to identify instead of vice versa. But maybe more substantively, regulatory barriers that I think just prohibit, in other words, take out would otherwise.
Yeah, that's cleaner.
Does the
Okay.
sandbox really seek?
Yes, we are the sandbox.
I mean, you could, but the objective of the
animal.
sandbox is to identify.
Yes,
I agree.
A little personification never hurt anybody.
That's my view.
Shall objectively identify?
Oh, you see the lawyers get involved in shall comes out. It happens every time.
Yeah.
The sandbox is intended to objectively.
Yeah.
May I
something.
suggest we go back to the prior language, because our first sentence is the purpose of the sandbox is, and I think if we have one sentence that says the purpose is and another sentence that says the objective is, it looks a little weird.
The goal of the sandbox, I don't know.
What about the personification that we had before?
This is what we had before. The sandbox seeks objectively.
But I don't generally like the passive voice, but I would say is intended to objectively identify.
Okay, I'm gonna bring out my heavy hand. If there are no further changes to this, it would be nice to be able to say, when we move this as a soft recommendation, that everybody's okay with it, or almost everybody's okay with it, or everybody's okay enough with it.
Go for it.
And keep in mind that if this does go before the entire group, right, there'll be more tinkering, right? So.
That's true.
Oh, yeah.
Totally.
Yes, because there's
Um,
more lawyers.
Yeah.
Guaranteed.
So is everyone okay with sending this up as the recommendation of this group?
Yeah, I say yes.
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 Any dissents or abstentions?
All right. You all are amazing. You did
Yes.
it.
Yeah, it's a nice piece of work.
Your folks' eyes with this.
And thank you, Neil,
for your,
for giving us a
yeah,
great
for your
start.
edit.
Yeah. All right, portion 1 is now concluded with a successful action outcome. And I'm bouncing the ball to Tom.
So I think what we're going to do is switch to page 2, sub C. We thought that would be the best way to kind of surface, the public protection objectives, which conceptually we were thinking would help drive the shape and form of the application process. So there are 4 listed here in approach 1. Approach 2 has very similar language, a little bit different, but I thought probably the best is to start with, should there be some form of efficacy or quality or competence screen? How does that value fit into what we want to do? And I'd like to recognize Toby because he did some thoughtful scrivening on this. So Toby, why don't you give us your thoughts on what is the quality of the stuff we want to come out of the sandbox?
Yeah, Patricia and I did this together.
Yeah, thank you, Patricia. My apologies.
And I guess the thought that we had was that we don't want that this should, whatever this new product is, this new service, however it's defined, that it should deliver services at the level of quality that, and we went around a bit at what level of attorney, but it ought to be equivalent of what lawyers do. So if lawyers make mistakes 10% of the time, this shouldn't make mistakes 30% of the time. People ought to be getting at least as good quality as they do when they go to a lawyer. We don't want to build into the system a sort of second tier level of access of quality. I don't know, Tricia, anything to add to that?
I think that's spot on. We should have the same or better, not worse.
Yeah.
Okay. And then let me just push a little bit. So what does that mean? Okay, so you've got somebody that is a wills and trusts kind of guru, and they'll give you this very cool trust, and someone comes in to I don't know, LegalZoom or something, and they just want your kind of basic will. Is that enough? Or how do we determine whether something is as good as in this context?
Tom, I hate to go back, but maybe it's the substantial benefit outweighs the risk test, right? Maybe that doesn't quite capture what Toby and Patricia are talking about, but I would think that that's a component.
I think that's right.
Toby, you're good with that? Okay.
Yeah, I think so. I'd have to see it sort of spelled out, but I think that works.
So the benefits exceed the risks of, the fancy thing might have been better, but this is okay for most people, right? Is that kind of where we're going?
Well,
Which would
Is that a front end or a back end determination? Is that how you get into the sandbox, or is
Yeah,
that?
so
I think that's a question. I mean,
Yeah.
my view is that it should be a yes, which
Yeah.
is part and parcel of the no guinea pig rule. I mean, I think that there should be some demonstrated representation about efficacy, and you see that actually even in the Utah stuff. What is this thing you want to provide? But does it do something good? I think I believe that should be part of it. But you could locate that, at the beginning, at the end. It could be part of the regulatory process. People get kicked out if it doesn't work.
So I
Yeah.
hate to do this again. I do have suggested language here. I'll put it up this time on the screen and see what you folks think.
Well, hold that thought. Let's do concepts first, and then we'll get to your language. So, in general terms, do we want a level of quality as a criteria for admission into the sandbox? And Toby's proposing that this should be, roughly what the quality that you get from an attorney. Patricia joins. So do we have thoughts on that one way or t'other?
One concern that I have is that I don't know how we know whether or not it's the same quality as you would get from an attorney. Since we don't know what the percentage of mistakes are that Wills R Us is going to produce, and we don't know what the percentage of mistakes are that current hang out the shingle independent operating lawyers make. But one possibility, if the goal is, and I think it should be, to ensure lawyer-like quality, maybe that means that one of the rules of our sandbox should be a lawyer is sufficiently involved and responsible that the lawyer can vouch for this being lawyer-like quality. And I'm not suggesting that that means the lawyer has to be the provider of the services. You could have a lawyer working in some supervisory or ancillary capacity with 25 other people, or with a computer and technologist where the computer does the work. But if you have a member of the state bar who says, I know the law in this area, and I know what quality legal services are, and I think we are providing them through this computer or this group of non-licensed people who go out and help clients or whatever. So in other words,
I think that's a cool idea. I mean, if you include it in the process, but you could locate that process at the entry point. So you could have, if there was like an algorithmic based technology that wrote wills, for example, you could have somebody that knows about that area of the law look at it and go, yeah, that result is generally consistent with the standard of practice, and that gives you the green light to start in the sandbox. You could also require that embedded within that entity would be a licensed lawyer that would do the same thing. So, I mean, but you could locate that in various spots, it seems to me.
So what Justice Tucker is, I mean, I think this is a great specific example to be considering, because the way you set these requirements up has big implications for who can get in and who can't, right? And so
Yeah,
this
sure.
model of sort of the legally responsible person is one that's used in particularly alternative business structures to make sure that the creepy non-lawyers are behaving according to the ethics of lawyers. But think about something like a community organization that helps people with wage justice claims or domestic violence advocates. These are people who already know that area of law really well. They know the part that they're working with really well. And it could be incredibly helpful to expand their capacity to, say, give legal advice or potentially appear in certain kinds of lower level hearings. If these are, where's that lawyer going to come from? So that becomes an expense that kind of activity has to take on in order to expand its capacity to serve the population that we're thinking about. So it's
of course, the legal aid now, I mean, I had a very nice conversation with a woman that heads up in the East Bay here in the Bay Area, the legal aid group that focuses on wage claims, labor type issues. And they very closely monitor their paralegals, but they use them extensively. So there is that. And Toby, you've probably got better examples than me, but what do you think?
So can we actually, I have an idea here. We can flip this. It's a good idea to have an attorney that is, more knowledgeable and skilled to say, hey, this is going to look like it's working or will work, right? But still, it's still speculation on the part of that attorney, right? So maybe to flip this is to actually say, hey, the way we try to control for effectiveness is that the sandbox, the regulators have to employ an audit of say X amount of certain cases, and that's part of the cost of being permitted entry into the sandbox, is that we're going to randomly audit a set number of your cases and check for effectiveness that way using an attorney that is maybe experienced, right?
I understand, but you're flipping the timing, which may be what the group wants to do, but you've created an experiment. So we're letting, Joe's Screen Door and Law Company into the sandbox, and then we audit them 6 months down the road to figure out if they make screen doors better than they do law. There's some issues there, which I think there needs to be a preliminary sort of assessment of efficacy is kind of my sense.
Yeah.
But
and hopefully, however, it will help in the front end, because if people or applicants to the sandbox know that they're going to be audited, they'll probably come together and be encouraged to come up with a more effective model.
I can add to this from the research compliance aspect of it, is that even if a research investigator knows that they will be audited, it doesn't necessarily mean that they'll follow all the protocols because life happens or for whatever reason. So I do agree that there has to be something on the front end before the harm is done. So that, having that tailored, the questionnaire of efficacy is really important.
So I wonder, I can see how you tested at the front end when the conversation was about an algorithm, right? You're having something generated, will generated by computer, and you can test it by algorithm. But so you can sort of take a look at that. But if you're not talking about a technology solution, so you're talking about sort of a new partnership that wasn't allowed to exist previously. So I'm not sure. So you wouldn't have that algorithm to test because they wouldn't have been permitted to provide this service up until they're granted access to the sandbox. So I think there's got to be some flexibility in how you assess the quality at the front end to allow entry, because I just don't know that we can come up with a hard and fast test before we know what all of the possibilities are that are going to be seeking entry.
But if there is a lawyer attached to it, we would have some type of, I don't want to use the word guarantee, but at least we'd know that there was a lawyer in good standing with the bar that is attached to the program.
Yeah, a pure ABS thing where, if, there was a non-lawyer that owned it and they followed kind of the protocols in the UK ABS structure, where the lawyer actually did the lawyer work or oversaw the lawyer work. That's probably that certainly would be a demonstration to me anyway, that was likely to be a useful service. That would be okay with me.
This sort of brings us full circle, because we started out saying, what are the requirements? What if the requirement that we set is that an applicant needs to explain how they are going to make sure that they provide lawyer quality services? And, we can give them e.g., like having a lawyer in charge who monitors and responds, or having a limited set of tasks that we allow people to do, and we only allow people to do it once they've had a certain amount of training, so that Becky's social workers or whatever sort of non-lawyer providers can operate without a lawyer, provided there's a clear explanation of how do we know they're going to do as good a job as a lawyer.
I think that may be the way to fix this. I mean, if you make it a, you know, the standard is lawyer quality, you got to tell us how that works and how you're going to achieve that, and be creative, whatever you come up with, we may be good to go. Marta, does that work for you? What do you think?
Yes.
I think that works. And if you look at the Utah application, that's the way they deal with it. They have a box you fill in saying, how are you going to assure quality?
Yeah, and they also have the box that says, what are the problems? How are you going to fix the problems? It's actually kind of a nice form.
Yeah.
Okay. So is that a
Wait.
solution? Yeah, go ahead.
So is everyone okay with the anchor being services provided by lawyers under the current regime? Because that then becomes the baseline, right? And so another way of framing the access problem is no services provided by any competent provider under the current regime. So the real baseline is the probability of getting service from a lawyer times the quality of the lawyer, which is a really tiny number. Whereas the quality of the lawyer, which 10% of people are getting, might be really good, right? So it's just whether the anchor ought to be lawyers per se, or some other statement about competence, quality, effectiveness.
What do we mean by lawyer quality exactly? Because anything is lawyer quality so long as it doesn't run afoul of the legal ethical rules, so long as it doesn't, it isn't a level of service that could support a legal malpractice claim. So I guess I don't completely understand what that means. I'd also just make one further note, which is that we worked out language when we were thinking about the purpose that did some of this work already, where we had something that was essentially cost benefit. It was essentially welfarist. It was essentially utilitarian. And that's different from a standard that's keyed to a measure of lawyer quality. Because if you're welfarist, if all you're looking at is whether the benefits of this service provision exceeds the costs, that's a different inquiry and gets you to a different set of results than something that's keyed to what we understand to be lawyer provided services in the current context.
Yeah, let me just push back just briefly. I mean, it seems to me at a high level that's probably right, but I'm not sure if we're going to balance, level of mistakes versus, the amount of money in play, all that kind of stuff. How do you do that? I mean, there's an administratability issue here. I mean, if I go to a practitioner of wills and trusts, he's going to say, yeah, this is the kind of thing we typically do. That I can go find easily. Doing a significant cost benefit analysis strikes me as kind of hard. But David, what do you think?
Well, I think that the notion of lawyer quality is no more sort of grounded in something that we can understand. Now, maybe if you put average lawyer quality, but then that starts to get really complicated and constipated really, really quickly. So, yeah, I think in the access to justice community, as I understand their arguments, they look at a lot of different types of innovations, things like online dispute resolution platforms, as an example. And they say that there is a really interesting baseline question to be asked there, because you're talking about providing services to a group of people that real lawyers stopped serving many decades ago. And so the baseline question is, well, there are a whole lot of services that would make those folks better off than they are currently in their own sort of lawyerless, self-represented efforts to solve their own legal needs. And so is the baseline a lawyer quality services, average lawyer quality services? Is the baseline what they're currently getting, which is trying to navigate a very complex civil justice system without much assistance at all?
Well, I don't think we want to be in a spot where we're saying we've identified this second-class population and we're going to give them second-class service. I mean, I just think just the whole variety of levels that's not a great idea.
How is that different than what we're doing right now?
Yeah.
By
And how is that different from the language that we just lovingly worked out where we talked about costs and benefits? That's a welfarist approach. And so folks who are getting more representation, folks who would get more representation than they currently are, might be, as a social welfare matter, as a benefits as against cost matter, it might be a better world. So if we are going to key something to lawyer quality, I think we probably need to go revisit that language that we crafted with respect to the purpose of the sandbox.
I suppose also another way you could look at this too is if this is becoming too difficult to figure out, the quality aspect here as a screening going into the sandbox.
Right, yeah.
Maybe the better thing to do is try to reduce risk going in, and like, for example, don't let in folks that have felony convictions. Don't let in disbarred lawyers. Require a moral character application process, and focus on those areas to maybe reduce risk. That's just another approach to the issue.
Yeah, no, and you see that in some of the literature. Although the other aspect of it is, are those risks the really significant risks? It may be that people don't quite know what they're doing. I think that may be the larger risk. So I mean, that's why I'm attracted to some version of Toby's test where it's, we look at what you would get from a reasonably competent lawyer. There is the duty of competence. I mean, there is a baseline. I mean, I admit that it's going to be hard to judge, but we don't want to put ourselves in a posture where we're just saying, we're going to let malpractice be, you can't not have quality as a criteria.
Or the other option
has to be bigger.
Or the other option is to have the board be the entity that decides, well, this looks like this is going to be a service that will be competent, and deciding whether or not to approve the application.
And that comes from having the application that says, how are you going to define and ensure or assure quality?
Right.
Yeah.
Competency and quality.
Yeah.
Like Utah.
Right.
Yeah, I agree with the Utah, a lot of the elements of the Utah application as well, and perhaps having somewhat higher level oversight, like the board for risk assessments. And I just wanted to speak, and it might not be perfect because I'm not an attorney, but on David's statement with that Mills utilitarianism. If we're talking about cost benefit analysis, if a lot of people save money, they might be benefiting financially. Like we might have a society that benefits financially because they get a service, but if it's a terrible service, then it's not going to help them in the long run. Yes, they had access to this legal realm, but they didn't have the quality of it. So and just to speak in plain language here, my fear is that someone who doesn't have a legal degree and wants to try to help people, but they go online and then they think that they're like the Google doctor or the Google lawyer. Just because they go into a system doesn't mean that they're going to have that level of knowledge. So I want there to be a distinguishing factor that yes, they get a service and it's going to help them, but they're at the end of the day, they're not speaking to an attorney necessarily. So they might want to get whatever they need, like a will or something, and then they might have to seek counsel. And it's a way to also defer people to attorneys to facilitate that communication path as well.
One of the things I know that we pointed out in our memo was that it's not just people who don't have access to lawyers now, but when you have this system, somebody who could afford a lawyer or would otherwise find a way to get a lawyer is going to say, well, geez, look, for a lot less money, I can go here. And they may not fully understand what the trade-offs and the what options they're giving up. by saving that money.
Mhm. Yeah, what that actually implicates the Utah situation, because they ask about what are the potential negatives, and they also ask how are you going to ameliorate or address those negatives. So, having off ramps to attorneys if things get more complicated than the Sandbox candidate is ready to provide, that might be part of the process for sure.
Yeah.
But so let me play this back because we got 15 minutes. So am I hearing, there's a question mark at the end of this, am I hearing that as at least part of the application process, we want candidates to explain to whatever this regulatory body is going to be, that how they expect to provide an efficacious product which will be as good as what they would get from an attorney? Toby, is that too far, or is that?
No, that works for me.
Okay. Thoughts on this, guys? I mean, it doesn't go as far as Justice Tucker wanted to go, but I'm trying to find a consensus
Fine
here.
with me.
Okay. Going once,
Let me
going
just
twice.
toss one other quick thing. And
Yeah,
when people were talking about, well, the social workers or the other non-lawyers, the good doers that are going to help. There is the other working group that's working in some ways in addressing that issue through the
paralegal type, paraprofessional. Yeah, that's
licensing of paraprofessionals. So we may not really need to fully address that. I don't perceive that those will be coming into the Sandbox.
All right. So go ahead.
Can I try one more? Oh, sorry, Becky, go ahead.
No, please, you go.
Becky, Justice Tucker, and then to David. Go ahead, Becky.
I mean, I think making lawyers the standard is going to create a set of challenges for people to demonstrate something that's impossible to demonstrate if they have a truly new service. So that's going to knock out a whole bunch of activity. I think making lawyers the standard is a challenge because we have very little data about how they actually perform the kinds of things that we're discussing, like how competent are they? How good are those documents? And it also raises the issue of whether it's true that something is not always better than nothing, but something is often better than nothing. So the will that doesn't preserve absolutely every one of my hypothetical interests that Tom could advise me about is probably better than having no will at all and has my children from different partnerships fighting with each other and stuff going places I don't want it to go and long-term confusion and expensive litigation to resolve it, right? So I think that's that welfare issue that David was raising. So I think that's something to keep in mind as we think about lawyers as the standard. Like it's a difficult standard to implement, both for the goals of the Sandbox and as a way of monitoring things. Anyways, I'm done.
Okay, Justice Tucker and then David. Justice Tucker.
Well, okay, so here's one thing that David said that I think is actually worth keeping track of, which is how do we define the standard of what lawyer quality is? I think it should be legal malpractice. And I think, if we take the long view here, and if we set up something that's going to happen, not just for a 3 or 5 or 7 year experimental period, but perhaps it's going to prove successful and the experiment will be continued into a permanent sort of new regulatory regime, there are going to be entities that are going to fall short and that are going to get sued for legal malpractice. And I'd like to, and so I think about, should they be held to the standard of lawyers? And I was mostly reacting to Patricia and Toby's, very strong statement of the importance of quality and not having a second tier level of legal services out there. But I think that the possibility of having a legal standard established for what's not good enough when these providers get sued for falling down on the job is good. And if it's not going to be the standard of a reasonably competent lawyer, the standard of care in a legal malpractice case, what is the standard going to be?
Yeah, I mean, there is, I mean, we could cross-reference to the, I mean, there's a duty of competence that Kevin, I'm sure, could tell me a great deal about. Yeah, point well taken. David?
Okay, so let me start out on a warm fuzzy note, and then I'll move to a really strident note. Okay, so the warm fuzzy note, fuzzy note is that these are really hard questions. I mean, and so I'm so glad to be part of this group and to offer what little meager expertise I can. I'm so glad that we have such a great collection of talent and experience. And so these are hard questions. That's the warm fuzzy note. Right. So now the strident one, which is like keying this to like, you know, a quality lawyer or quality lawyer representation is, in my view, one of three things. It could be contentless. It could be meaningless, because immediately raises questions about whether we mean an average lawyer or whether what we really mean is legal malpractice, which is kind of a consumer harm standard anyway. So one possibility is it's contentless. Another possibility is it's really strict. And that it's a toehold or more than that. It's a big foothold for the bar that wants to stymie innovation to come in and say no to most of the things that try to get into the sandbox that could very well ultimately prove to be really salutary types of innovation. So that's the second possibility. The third possibility is it's almost like a category error for a reason that I put in the write-up, such as it was that I provided for this meeting, which is, you know, a lot of the innovations that we're talking about, especially the tech ones, really embody this idea of you know, the decomposition of legal services. So some of these innovations are doing a tiny little piece of what lawyers do, and like they're necessarily going to be inferior, or at least are hard to compare to what a lawyer does. Because a lawyer, the reason why we like lawyers is, you know, that they see things in all 360 degrees and they see around corners, and they can offer, you know, full scale representation, soup to nuts, etc. And that's not what some of these innovations are going to do. So the third possibility is that keying this to like quality lawyer representation is actually like not an apples to apples comparison, and not one that we should be importing into this inquiry. So I guess I just keep coming back to like, you know, why not just say competent legal services and leave it at that? There may be real virtue and real value in keeping this at a fairly high level of abstraction, rather than opening up all sorts of cans of worms with references to what lawyers provide.
So let me just play that back to you. So if we made efficacy, defined it as the equivalent of competent legal services, that works for you, David? Or did I mishear that? Or
that sounds good to me, but I would love to hear what other people think about that. You know, competent legal services, does that get us up to a slightly higher level of abstraction and doesn't beg lots of questions or create those footholds that we don't want?
Yeah, Marta and then Toby. Marta, what do you think?
I wrote down right as David started talking, competent legal services.
I love you.
I think that's exactly what we're trying to, the goal is access to justice within the confines of the legal marketplace that we have existing, whether or not that's going to change over time with the sandbox, or however historically it's going to change, which it always does. You know, we need to know how these people are going to provide competent legal services to their audience, to their clients, to their customers, period.
Okay.
I think it is, I don't know if we want to, I think tying it to what an attorney could do is going to muddy the waters.
Okay, that works for me. But so to you back, Marta, a question. So David raised this point, which I think is a really important one. Some of these things, some of these services disaggregate the legal experience. You know, like people will help you fill out the form for your divorce in terms of your financial situation or your bankruptcy application form and that kind of stuff. So it's not the whole 9 yards, but a sub part of it. Do we need special language to take that into account from your perspective, or does competent legal services encompass the notion that these guys may be doing a small part of a bigger service package? one typically.
I'm sorry, could you repeat the first part of your question again? I was distracted.
Sure, no worries. In
Okay.
terms of an alternative service provider that provides a part of what lawyers provide, for example, fill out a form for family court or fill out a form for bankruptcy court, do we need any special language to take that into account? Or does competent legal services include subparts of the service package that one typically gets?
I think that is inclusive of that.
Okay, I think that would be.
You can provide unbundled
Is
services.
that addressed in the second point about transparency as to the weaknesses of the service that might be provided? That, in other words, we're just providing one aspect of it, but you also have to consider this, this, and this. Would that be part of what
I
we
think
would
that,
require?
yeah, I think that would be the way. I mean, we could do efficacy. The efficacy standard would be competent legal services, and then the transparency aspect of this would be, you got to, a la the Utah application, you got to tell us what the limits are. You got to tell your client or your customer what the limits might be in terms of your service. You're doing this chunk, not the whole 9 yards. Yeah, I think that's a correct insight.
And of course, a lot of lawyers do that too.
True, yeah.
The services, lots of lawyers do this piece of it and, leave the client on their own or to find some other lawyer to do the rest of it. That has been going on for a long time, and the State Bar, in fact, has been pushing that for many years. So I think that's not a differentiation. I mean, if what you're proposing to do is this piece, then you've got to do that piece competently.
Yeah,
then the
that sounds
question
right.
is doing that piece competently include advising the client of what the other pieces are that you're not doing, which I think
Okay.
for lawyers it is. But if all you're doing is filling out, say, a domestic relations dissolution petition for the client and the initial paperwork, you have to explain to the client, here's some of the things that are going to happen in the future and some of the timelines you might be facing, to do that piece competently.
Okay, all right. So let me step back because I got 5 minutes to get to yes here. Am I hearing that we like competent legal services as the term of art we're going to use in terms of efficacy? That means we are sort of going to think that should be some part of the calculus, and that, as Toby suggested, and actually Kevin's point, that in terms of transparency, explicating strengths and weaknesses, that would cover what you don't do in the context, I presume. So are those two things together acceptable to the group? Going once?
What do you mean what you don't do? Are you talking about the no guinea pig rule? Is that what you're referencing?
Yeah, well, that would be part of it, but it would be a disclosure of the strengths, weaknesses, and limits of the service you're providing.
Ah, okay.
That combo would work for us conceptually as a group.
Yeah.
Okay. I'm taking that as a yes. He says very tentatively. All right. Okay, why don't we go on to privacy? So that's a question. There's a lot of, I got 3 minutes on this one. Privacy, there is a absolute duty of confidentiality that lawyers have. Some of these are going to be tech firms. Sometimes they sell the information. I mean, there's all kinds of interesting issues. There's also a group of state statutes led by the California Consumer Privacy Act, which address this. What, if anything, do we want to say about privacy? You got to meet the lawyer standard, or can you get by meeting the CCPA standard, for example? How hard-nosed do we want to be about that?
My quick thought about this is that it's hard to say until you see the applicant's model, right? I think it would make sense to say something more generalized, like, for example, the Sandbox may require the candidate/applicant to comply with various privacy rules or to comply with the rules of confidentiality, attorney-client privilege. I think it's hard for us to come up with those with parameters right now until we actually see them. I think the best we can say is that we might tell candidates to have to follow these rules, right?
Yeah, well,
I would think that
I think some of these statutes are going to apply irrespective of what we say. I mean, CCPA is likely, but anyway.
Right.
Yeah.
But we can see that on a case-by-case basis, right?
Okay. Further thoughts on this?
Yeah, just on confidentiality, I'm kind of a strict confidentiality maven in terms of you don't gossip about your clients, for one thing. But what we learned from some of our tech people on the ADLS or ADLS task force is that it is possible to, I hate verbizing nouns, but they said anonymizing certain information that they might collect. And isn't that going to be necessary if for the regulators, in order to be able to assess what they're doing, they're going to have to be able to monitor and assess certain confidential information that is going to have to be provided by these people in the sandbox or these entities in the sandbox. You can say this is an exception, but I understand that a lot of the data can be made anonymous before it's submitted to the regulators.
Yeah,
So,
I think more the question would be, I think about Google or Facebook. I mean, they give you a service and then they take your personal information and turn it into money. So for example, you could have, say, somebody that fills out your bankruptcy form or your divorce form. They're going to know a lot about you financially. That might be of interest, and they're going to want, people will want to sell to you as an individual, arguably. But David, have I wildly oversimplified that? Or?
Well, so in my write-up, I think there are three different layers to this. There's the attorney-client privilege, there's the risk of commercialization, and then there's what you could call cybersecurity. So just think of data, like that's a stand-in for the idea of data breaches and the notion that a provider has to, have reasonable protections against hacking. So I think you're right, Tom, that you mentioned that the cybersecurity stuff is probably already covered by the CCPA. I mean, the CCPA is largely a set of regulations around what precautions have to be made to prevent data breaches. The question where I think it starts to exceed my understanding and expertise is the difference between the attorney-client privilege layer and the data commercialization layer. So are there uses of client data that would be commercially valuable, that a provider could, make some money off of, that wouldn't run afoul of attorney-client privilege? And there, I just don't know enough. If the answer is no, then those two things are one and the same. Then we would think that most or all instances of commercialization of data derived, or acquired by an alternative legal service provider of some kind, would always violate attorney-client privilege. Then there's actually only two layers. There's the cybersecurity layer and there's the confidentiality layer. But if I'm wrong about that, if it's actually more of like a, if it's more of like a Venn diagram or something, who knows? But if there is an overlap there, then there's a further question as to whether we would want data commercialization constraints that go beyond what would be required by the various strictures of the attorney-client privilege.
Yeah, I think if we, and this is an issue, I think if we apply the ethics rules, there's an absolute duty of confidentiality, so you couldn't sell stuff. But I think, I'll defer to Kevin on that, but I think the possibility of tech firms is some of their business models involve selling personal information or, monetizing it in some fashion. But Kevin, can you illuminate this issue for us?
Okay, one problem with the privilege, it attaches to the communications between lawyer and client. So they couldn't disclose that because that would be waiving any privilege unless they're not interested in having the privilege, but they would have to disclose that to their respective clients as part of their transparency obligations. As far as the duty of confidentiality, that applies to everything else. So, a lawyer has a duty of confidentiality. You don't gossip about your clients. And if you're talking about the commercial sale of client data, I'm not sure that it's going to be of particular value to other marketers unless it's tied to a particular person with an identity. So they can be tracked, or at least their cookies can be tracked.
Cookies,
So it's going to be really problematical to permit this, but that might undermine the ability of, say, a tech company to provide services at a particular price point, is what I'm guessing.
yeah.
Why, sorry to jump in, but what would be the argument for not requiring these tech companies or anyone else who enters the sandbox to require with the lawyer duty of confidentiality? I can hear from this conversation that tech companies or others might be motivated because they could sell some of that information and it might motivate them to enter the market. But my counter argument would be, you're choosing to voluntarily enter into the legal market. There's certain obligations that are owed to clients who seek legal services. One of the most paramount ones in all 50 jurisdictions, and especially California, is the duty of confidentiality. And I would, as an ethicist, I would strongly encourage, at least at the outset, we require that the participants maintain client information as confidential as lawyers do.
Yeah, let me just, not to be devil's advocate, this is my job today, but if for example, I mean, people signed up for Facebook, which is just, I mean, you're selling your most intimate secrets to be part of that social media site. But people do that every day. They do Google searches every day and they get something they think is valuable and they hopefully understand the trade they're making. So conceivably, if a tech company could monetize some of that data, it might reduce the cost of their service and might also give them some, capitalization so they could actually innovate in this space. I mean,
Yeah, no, I'm with you. And I'm sure they could do a click wrap and say that they're disclosing all the harms that a consumer who might be unsophisticated or sophisticated, because, who wants to read through all those things before they say, yes, I want to use the service, and they're going to waive their protections under the Business and Professions Code with respect to confidentiality or the attorney-client privilege. They might do that. But Facebook isn't legal services in my view. And also this could unwind other issues if we want to somehow build in strictures concerning conflicts of interest later on. So if you don't want a particular entity to be adverse to a particular person who's using that service, well, the duty of confidentiality is going to be core to that protection. So I'm not sure we can resolve this in the next 5 minutes, but my only offer here is to tread carefully. I think this is pretty difficult.
Yeah, so it sounds like you and Kevin are a dyad here, it sounds like, but okay.
Yes, I pray at the mount of Professor Moore.
Sounds right. I think I might light a candle there too myself, but anyway. So do we have any kind of consensus in terms of how we want to think about privacy? Is our default that we want to ensure duty of confidentiality level protection? Marta's saying yes.
I just want to raise one issue. So whether I'm a lawyer or not a lawyer, this regulator could require me to have lawyer-like confidentiality behaviors. But privilege means my lawyer cannot be compelled by any third party to share the information I have given in the context of that relationship. But if I'm not a lawyer, that duty of confidentiality does not have the additional level of privilege protection, which means I can be compelled to have this disclosed. I don't see how to get around that. I mean, we can't create privilege and give it to social workers. But how do you think about that in the terms of transparency and privacy, and how do you let a consumer know that this has happened and that what it might mean?
Well, I think there is a potential for disclosure beyond the click wrap thing, which is awful, I think. But in any case, you could disclose a bunch of stuff. But Toby, what do you think?
Yeah, I mean, I think, there are examples of places where the equivalent of attorney-client privilege have been extended. beyond lawyers. So lawyer referral services have the equivalent of attorney-client protection. It requires a statute to do that because privileges in California are all statutory. So you could have a statute that says that, you know, participants in this sandbox have a privilege that's equivalent to attorney-client privilege, and if and when the sandbox expands, whatever defined activities we include could be added, you know, to that kind of protection. But you raised the issue I was going to raise, and that is that privilege is very different than confidentiality, and you need both.
Yeah, it's the duty of confidentiality. I think it's the big one here, but thank you for that. So maybe to you, Andrew, can the state bar provide privilege? You guys can't, can you? Or that's a legislative deal, right?
Right.
Correct.
Okay.
Both the duty of confidentiality and attorney-client privilege are statutory constructs.
So I thought, okay.
Although confidentiality is also regulatory.
Yeah,
Yes.
right. Of course, there's an
Yeah.
ethical rule. Yeah. Okay. All right.
And, I'm not sure if you could see, Tom, Marta has her hands up. I'm sure she has.
Oh, Martin, please. Yeah, go ahead.
I mean, I think this is a really tricky issue because if you're having the delivery of legal services being done by somebody other than an attorney, then the duty of confidentiality doesn't necessarily, it doesn't translate as it's currently exists to that paraprofessional, whoever that is. But I think this is a very difficult issue because I think to Rebecca's example earlier about a guy who wants a will, but is coming to get, to make sure that his property is divided as he wants to with all his family members. If we don't have some type of protections in order, what's going to happen to that man? What's going to happen to those family members if there is a sharing of all that data and all that information by the paraprofessional or whoever that is that's delivering the will to him? And I think this is a really, really important aspect of our work here, and we have to tread very, very carefully. And I echo Kevin and Andrew's comments on this because this is difficult.
Okay. Let me, because my sense is we're not going to resolve this now, but let me turn to you, Marta. Is there like a staff thing or a report or a little research thing that would help you grapple with this issue in an informed and useful way? I mean, should I find a speaker? Is there anything that would be helpful here?
Well, I think we have some competent people on this panel that teach to this very issue. I just don't, if there is somebody who could speak to this, who could address this issue, I think that we would all benefit from it.
Okay. Sounds like we need more time on this.
Yeah.
Maybe would it make sense to you, Kevin? I'm going to put you on the spot. Could you just do a little overview of this at our next meeting? You and Toby. I can't hear you.
I have three screens and I had to move the.
No worries.
Yeah. Okay. I guess when you say the next meeting, our next plenary meeting or the next meeting of the subgroup?
I think the subcommittee. I think we should try and make a recommendation.
Okay.
This is a sticky wicket, it seems to me, and we should give them guidance. At least my sense. I mean,
And in the meantime, I'll try and get some insight into how Utah is dealing with this very issue.
Okay.
Would be of some help.
Okay. And to you, David, do you have any expertise in the CCPA? Because I can find somebody on that if necessary.
I wouldn't call it expertise, but I know something about it and I'd be happy to bone up on it if that would be useful.
Actually, could I ask you and Kevin to get together and just for the next meeting present on the overlap between CCPA and the duty of confidentiality? Because my impression is it's not just data breaches. There's also, if you're going to use my data, you got to disclose it to me. I get to say yes or no. I mean, there's some nice language in there which I think might be helpful.
Yeah, that's right. There is an opt-out. There is an opt-out right. So
Yeah.
you're absolutely
Okay.
right. I would be glad to do that as long as Kevin's willing to have me in that enterprise.
By all means.
All right. Thank you both. I appreciate. I
And I
think
throw
we've got.
one more idea in on that discussion. I think Kevin's point about the fact these are statutory privileges and regulations is important, because I think our sandbox is going to go forward only if we get legislative buy-off on the entire enterprise. And if part of the entire enterprise is asking the legislature to extend attorney-client privilege type protections to sandbox entrants, that's something we should identify as an item and an element. But we shouldn't feel that we have to operate under today's statutes as we go forward with the sandbox.
Oh, that's a very helpful insight. That's great.
Yeah.
But I think let's hear a little bit more about the CCPA and the duty of confidentiality, and then we can at least articulate what we want out of this process, I think, as a group. So
Can I just quickly, sorry.
Yeah, Patricia, go.
While David and Kevin are working on that, I just want to see if you can also look into the downstream availability of pulling this data. Like if a researcher wants to go in and contact these various entities to do some research, anything like preparatory for research, they're going to have to get permissions. And, if we're talking about de-identified data and things like that, it's great that we're going to have this system in place, but we would also want to expand that so that we can have researchers perhaps contact people and have permissions to contact people to see how it's working. So thank you for letting me add that.
Yeah. No, that's an interesting question. I think there's probably the regulator, because we're going to want to know stuff or the regulator will want stuff. But providing information to researchers kind of makes sense to me, although you could anonymize it and do stuff. But David, would you see if there is something in the CCPA that's useful in those regards? I just don't know if the legislature touched on that at all. But
Sure. Yeah. Glad to add that.
okay. So we've got about 10 minutes left. I think we've gotten about as far as we can on these hard issues, but can I just walk you through the Utah application form and just get some reactions? Because I think we might be able to make some headway. At least in my package, it's, and we sort of touched on this.
It's the very last thing in the package.
Yeah, it's the last bit in the package. And there's this kind of prefatory thing from the Office of Legal Services Innovation. The first one is, describe your proposed legal services offering in detail. Who provides the legal services, how consumers will receive these services, and what your service will do for your customers. Does anybody have any concerns, issues with that? So what are you going to do, and how are you going to do it? I mean, it's kind of the deal.
Yeah.
Going once, going twice. I'm writing OK in the corner of this page. Okay.
Can I back us up a moment?
Yes, of course.
Two things. First of all, we didn't get a chance to see Neil's language on the subject we were talking about previously.
No, the subject became a lot larger than what I'd written, so it wouldn't be able to.
I recognize that. And the other thing is that in the document you sent round, before, that was still part of the first document, there was a section D on eligibility for entry and scope of regulation. And
yes, you're absolutely right.
I think that's a huge and very important topic.
Yeah.
That we haven't even touched on. And recognizing that I'm raising two things and the meeting ends in 11 minutes, I don't know how you want to handle it, but
actually, let's talk about eligibility, because that's a big deal. So I think, at least conceptually, the two poles of that conversation is we're going to focus on the unserved and underserved, full stop. That's what gets you in and keeps you in the sandbox.
Yeah.
Or we are dramatically more open to that, to pretty much anybody. And then there may be a middle position, which I think is represented by, if you look at G, which is on the next page, on page 4, there's something, it's at the bottom of the first chunk of bullets on G. Structured approach, like the open approach, but with criteria for determining whether a proposal increases access to justice and or non-waivable requirements for protecting against consumer harm. So one part is just for unserved and underserved, wide open. This would be ABS for Big 4 accounting firms, or something more focused. So any perspectives, thoughts on how we want to approach this idea of eligibility for entry?
So just an observation that connects to some of the things that David wrote about and also has been saying. So there are a couple of things to think about. So one is what's going to create the access to justice, the ecology of things that's permitted by the sandbox, so that on the other side of whatever that is, we have more access to justice, or you can evaluate that for each specific entity. I think that's one question.
Yeah, good point.
The other is, if you're going to evaluate it for each specific entity, what's the timescale for when that access increasing innovation has its impact? So we just got a proposal in the sandbox in Utah that reads contracts, and who makes contracts? Well, businesses make contracts, and so it does fancy stuff to assess the contract. But if you're looking at employment contracts from the employer's side now, that could make a product that I could access as a consumer in 5 years that lets me get some cheap, easy legal advice about whether or not I ought to sign up for this job under this set of agreements.
Mm-hmm.
That would be a spin-off of having the rich people who can afford to invest in this technology now, get it developed, and then it's like the iPhone, it gets cheaper and then many more people can have it. So to what extent is that a consideration in thinking about the innovation access relationship? That's all.
Yeah, no, I think it's a fair question. I mean, and embedded in that would be, how long do we give them? Do you need to demonstrate unserved and underserved are going to get help 2 years from now, 5 years from now? So I there are those kinds of questions. But yeah, I mean, if there's, the iPhone example came up in one of our previous meetings. I mean, that technology was consumed as like a Tesla by fairly wealthy people, and presumably that tech will work its way down. But with a trickle down strategy, how quickly should we be thinking about that value getting to the folks we really care about? I mean, that would be a question. You could also think about it potentially, would we be interested or open to, say, Price Waterhouse wants to buy a law firm or support a law firm in order to provide big law services, but they're going to provide services to, the family law court in Solano County. I mean, as sort of a price of admission. Is that something we would consider? I mean, I don't know.
Let me toss out some immediate reactions without,
Yeah, sure. Go ahead.
Think it through. It seems to me that, if my initial reaction was, well, if the Big 4 want to, open a law office and they're going to have a branch office in East Los Angeles providing, bilingual services in immigration and housing and stuff to low-income people in East LA, then, if that is going to work, fine. If their proposal is to provide, take clients from Big Law and, give round the clock, round the services, full services to them, doesn't meet the test that I think we defined in our preliminary, because I don't see that ever trickling down, if you will.
Okay.
So I think that there has to be some explanation of how is this going to meet that purpose statement that we came up with. that says it's designed to help underserved groups. And without that, I think it doesn't get in the door.
Okay, so just to play that back to you, Toby, it would be, how are you going to serve the unserved and the underserved, however we define that?
Yeah.
And you got to actually do it,
Right
now. Okay.
So I
Folks
think
have-
a lot of the action here is going to be on our definition of underserved. There's pretty good evidence that the big law sector focuses on corporate entities and provides a lot of very sophisticated bespoke legal services to corporations, and that everything else is people law, and that people law has been shrinking in recent decades, and that there are unmet legal needs and therefore underserved populations that stretch surprisingly far up the socioeconomic ladder. And if we agree with that proposition as a group, then it is not hard to see a lot of trickle-down potential, even with entities that start out representing some fairly large businesses.
So David, actually, I think in section B of today's memo, in approach 2, it's written, it is recognized that well-known justice gap extends beyond low persons to middle-income people and small businesses. That sort of hits on your point, I think.
Yeah, and one on that point, cross-references the Justice Gap report, which makes a very similar kind of statement, actually.
Right. Yeah.
Yeah. Yeah, David, did you have more? I'm sorry.
That was just a thumbs up to Neil,
Okay.
to Neil's point.
Okay, cool. All right.
One thing I will say is that I'm kind of reluctant about the idea of even having a 10% ownership interest by disbarred lawyers. We're here in California. I know Utah has that rule, but say for example, we're talking about a hybrid legal service that's worth a $10 million company, right? A 10% interest is $1 million that would be in the hands of a disbarred attorney. So I'm just saying from our consumer protection viewpoint, I wouldn't allow disbarred attorneys at all. So
I agree. And a member in good standing, or, that's not under investigation or resigned his or her license because they're being investigated, or they're being investigated currently when they're making their, at any point in time.
Or their last name is Girardi.
Or their last name is Girardi.
Oh yeah, he used to be a great lawyer, but so is there agreement on that? No disbarred lawyers in the financial mix?
I would join with that.
Okay, yeah, I would too. But what do you guys think?
Just one question. So what if the unthinkable happens and some of these firms become publicly traded?
Oy.
Yeah.
Please now.
How would we? Well, I mean, in Australia, there are publicly traded law firms.
No, there are.
How
Yeah,
would we?
sure. Also in England. No.
Yeah, and Australia's upside down, and there are all kinds of crazy things about it. But I mean, is this then prohibiting that? Which is fine.
I don't know.
That maybe something this group wants to do, but
I don't know if that would be a sandbox as much as it would actually be a quarry. because that would be a very rocky situation.
Oh my! Oh my!
Another way we can worry about.
It's lucky you're almost at the last word, Neil.
But yeah, I don't know. That's a valid point, Becky. I mean, is this something that we want to consider in terms of like allowing a publicly traded company? I would think that's getting way ahead of ourselves here. But
can I ask just a quick question about this? The limitation is simply that of an ownership interest, right? Not that a disbarred or suspended attorney would not be able to be employed by a company that's entered the sandbox. Is that correct?
I'm thinking it's both. That's even worse.
Yeah.
But well, I'm only thinking of is it rule 5.3.1? I mean, the rules of professional conduct permit disbarred and suspended attorneys to do certain things within a law firm, and there's a policy with respect to the concept of rehabilitation. So I don't want to distract this conversation, but I think if we limit it to ownership, I think we're on solid policy grounds. If we expand it to, couldn't answer phones or make copies or do other things within the organization, that might be a heavier lift, but I'll just put a pin in that for us to think about later. I do think there might be a distinction there.
I think Rule 5.3.1 defines some good parameters for where you could look at for that.
Yeah.
It also defines a term more broadly than disbarred, because it also includes, resigned with charges pending, anybody who might, be equivalent of disbarred, and then forget the term that's used in the rule. I know we spent a lot of time on the commission coming up with what that term might be.
Well, could we solve this by, because there are disbarred. There are supervisorial requirements associated with somebody on essentially being on probation, correct, Andrew?
Mhm.
We could
Yeah.
those kinds of
It's
things.
same in this context. Yes.
Okay.
So you could build those things in if you wanted to.
All right. Let me ask, because I've got 1 minute here. Why don't Andrew and Toby, would you guys mind putting your heads together and giving us some guidance on this? Come back with some sort of proposal with respect to the disbarred, et cetera, et cetera.
Sure.
Okay. Would you, Andrew, that's okay with you?
Absolutely. And that's
Okay.
for the next subcommittee meeting, correct?
Next subcommittee, yeah. So
Got
let me just play this back. I think Becky did way better than I did, but I think we did make progress. I think we've got what I described as efficacy. We've decided that collectively that the metric here for us is competent legal services. And we like the idea under transparency of the candidate addressing strengths and weaknesses consistent with the whatever it is that they want to do, which is consistent with the Utah application form. And on privacy, we've kind of farmed this out to David and Kevin to do some thinking about both the CCPA and its potential application and the duty of confidentiality. I think that's about as far as we've gotten, except for this thing I just asked Andrew and Toby to look at, which is this question of disbarred lawyers. Does that sound like about where we landed with respect to my part of this? Going once?
Sounds
going
good.
And I
Okay.
think we reached a very important, I don't know if it's maybe not yet consensus, but important point on issue D, which is that in addition to the changes that specific changes you're talking about relating to disbarred attorneys, that we are going to add that someone's only eligible for the sandbox if they have a specific proposal for how they're going to be improving access to justice. And I don't think we've had a chance to discuss whether that we're going to leave it at that or whether we're going to have some sort of criterion spelled out for what we mean by that, whether it's what the timeline is or what counts as improving access to justice. But we are going to require that is part of your proposal if you want in.
Yeah.
I think that's a pretty important addition to what's currently on the paper. And I think that may be an area that we're going to talk about more, that your group will bring to us to talk about more for the April 9th meeting. Because in terms of, we hope to have a scope document coming out of the April 9th meeting that perhaps still has some places for refinement or some holes, but this seems like a pretty big issue that I hope will be part of the report that you bring to the entire meeting for April 9th so that we can hash that out collectively.
Okay. I think that sounds fair. But I do, what I think I heard, and folks correct me if I'm wrong, is that when Toby was talking about this, the example we used was big law, big four accounting firm wants to do big law stuff. But if they open a clinic in East LA, that may be good enough for us. That kind of a strategy, I think people are open to. Is that by misrepresenting you, Toby, or misrepresenting the group?
No, I think my thought was if that's their proposal is to do that, not if that's a sidelight they're going to do while they're eating Big Law's lunch. That wouldn't be good enough for me.
Okay, all right.
It has to be the focus of the proposal, not a sideline.
Okay, all right. Useful. Okay, thank you all. Very good discussion. I do think we made progress. And I think, unless folks have, anybody wanted a last word? Because I think we're essentially adjourned. Becky, anything more you want to cover? Or?
I was just so educated and delighted by the conversation today. These are really thorny issues and everybody brought their best. And I just think this is great. What we eventually come out with is going to be good because you all are so smart and so thoughtful and so engaged.
Well said. Last word. Thanks all.
Bye all.
Again, everybody.
Bye.
Bye.